shall continue from the last topic we examined. And I'm sure for those who were present in our last class, we did examine the nature and features of the Nigerian legal system. And it was upon the conclusion of that topic that we moved on, that we'll be moving on today. So like I said in our last class, today we will be looking at the idea of law. The idea of law. And the idea of law, and the subtopic is law and its role in the society. Okay? And by way of introduction, I would like to say that the entire world being a place has its own governing rules. So that is to say that there is nowhere you go on the surface of the earth that we do not have laws or rules that govern human behavior. And apart from that, we have laws in place. We also have law enforcement mechanisms that each community or society have put in place to ensure the smooth running of the society. For example, in Nigeria, which is our own place of domicile, we have our laws. This law is what regulates the society. And apart from the fact that we have our laws in our law books, we also have the system to ensure enforcement of those laws. We have the instrumentality of the Nigerian police force. And that's why when an individual who knows deeply in his heart that he has committed an offense, if he sees a police officer approaching, even if the police officer is not coming for him, he may look for a way to escape from that environment. And that is simply because he knows that if he is found out, the law enforcement agents might arrest him. The same thing applies all over the world. And if that situation applies all over the world, another thing that we can add to it is that the system of each community has also put in place penalties or punishments for anyone who will violate the law of the society. Therefore, the law puts in place sanctions, which are punishments to be meted out to individuals that offend the law. Now, what is the essence of putting the law in place? What is the essence of putting the law enforcement agents in place? What is the purpose of providing sanctions and punishment for those who go contrary to the law of the land? The purpose is for peace and order in the society. And the society we are talking about comprises of every individual that resides in the society, whether indigenous or non-indigenous. So, to this end, roles in the society. And it is this same law that regulates our desires. This law also places some form of restriction on the state. That's why the state, as an authority, cannot do anything contrary to the law that is operating in the country. There are some things that Mr. President may do today and they can be declared null and void because they violate the ultimate law of Nigeria as a nation. So basically, law provides some form of restriction, some form of regulation on human behavior, and at the same time prescribe the rules of behavior or the basic structure, standards, and conditions that are to operate in a given society. So consequently, we submit that law is necessary to maintain orderliness in the society. Apart from that, we submit further that without law and law enforcement agencies, society will be in a total disorder, a total mess, that individuals who are citizens and non-citizens that live within the community may find it difficult to enjoy their lives. Apart from that, they may even find it difficult to live a normal life because the society will be full of disorderliness. And then living right and living properly will become difficult for everyone within the society. So, therefore, the existence of law and law enforcement agencies is necessary for the overall interest of everyone within the society, for continued protection of persons, properties, and freedom within the allowable space in the community. So law is very crucial because aside the fact that I said earlier that law regulates human behavior, law also dictates to the leadership of every society how they should behave. And that is what aids orderliness. And that is what takes away arbitrariness within the society. Because if there is no law in place, the leaders could wake up any day and do what they like. And doing what they like will be to the detriment of everyone within the community. So therefore, law is crucial to a stable or for a stable society. And then taking it further, we submit that in order for normal life to continue within the society, in order for businesses to thrive, in order for people to be able to exercise their fundamental right within the society, there are four things that must be in place. And one of it is law. Number one is law, the courts, the personnel of the law, and lastly, administration of justice system. Because if all of these four are absent, then the society will be faced with a lot of challenges. And as a matter of fact, there will be no society again, because chaos, anarchy will have taken over the entire space. So that takes us further, and then we ask ourselves, what is law? We ask ourselves that question because as people who are learning about the law, there is need for us to know what the law is, because it transcends just saying that law is a rule or law is something that makes people to do what the government wants. We need to have a deeper understanding of what law is. And I would like to let you know that prior to today, scholars have tried in so much ways to define law. But the unfortunate, whether we can say it's fortunate or unfortunate, is that there is no single definition of law that is acceptable, that is free from every form of criticisms or challenges. So that is to say that there is no perfect law, perfect definition of law. No perfect definition, because the various definitions that have been advanced by scholars have been found to have one defect or the other, or possibly because they are not able to meet every expectation of the society. So we put on record in the course of this lecture that there is no universally accepted definition of law. But generally speaking, we can define law as a rule. As short as that. We can also define law as a rule of behavior. Aside that, we can define law as the rules and regulation of a particular people. A particular people can be a society, a particular people can be a nation, a particular people can be a region, as the case may be. But irrespective of the geographical boundaries that we're talking about, law is the rule and regulation of those people. Another way law can be defined is that law can mean the whole system of rules of a country. The whole system of rule of a country, that is, the body of laws that govern their existence, that regulates their way of life, that regulates the way they behave, and so on and so forth. So that is a definition that has been put forward. Now, what we do in the course of this lecture is to move forward to examine some definitions as provided by some scholars. This will further give us more understanding of what we need to know as a student of law, or as a student aspiring to have the basic knowledge of law. Now, one of the first definition of a scholar we are going to look at is the definition put forward by Oliver Wendell Holmes. The definition of law put forward by Oliver Wendell Holmes. And Oliver Wendell Holmes defined law as the prophecies of what the court will do, in fact, and nothing more pretentious. That is the definition of law that Oliver Wendell Holmes has put forward. What I will do is that by the time I'm done giving these definitions, I want to hear what your views are on this definition, whether it addresses what you consider law to be or not. And of course, that will also aid our understanding of this particular topic. So Oliver Wendell Holmes said that law is the prophecies of what the court will do, in fact, and nothing more pretentious. Another scholar also said, another scholar with the name Sir William Blackstone. Sir William Blackstone also defined law.
Sir Benson. Excuse
Hello?
me, sir. Yes, sir. Sorry, sir. What you're written now seems familiar, like you started all before. So, started that topic.
I can't hear you.
Can you hear me, sir?
Yes, I can.
So the topic you're treating right now, it seems like we've treated the topic before. It sounds quite familiar to that of our first topic when we started your class, sir.
Yes, you started when we got to this point. You joined us. You joined us when we got to this point, and that was not for your class.
Oh.
I've explained this to you severally. I've also asked your coordinator to have a meeting with you to explain to you. Your regular classes are, just Wednesdays and Fridays, and Monday. The other classes that you've been joining are classes for other levels, but you take the same course content. So you have a duty, even though you have listened to the lecture through those other classes, I have a duty to teach this topic in this class, because that other class is not a compulsory class for your class. If you have attended, you have listened to the lecture, that's good for you. This will serve as a revision for you. But there are people in this class who only attend the ICE class. So I'm duty bound to teach them as well. Is that taken?
Yes, sir. Yes, sir. Thanks, sir.
All right. So, another who is email happiness? Person is raising his hand. You have a question?
Sir, that was me.
All right. So you can please drop your hand so that we, okay. So, well, I've just given you the definition of Oliver Wendell Holmes, who said that law is the prophecies of what the court will do, in fact, and nothing more pretentious. Another definition put forward by another scholar is Sir Williams Blackstone. He also gave his own definition and said that law is the rule of action which is prescribed by some superior and which inferior is bound to obey. Another scholar also gave another definition of law, which is Herman Clockman. Herman Clockman defined law as the whole reservoir of rules on which judges draw for their decisions. Then another scholar by name John Austin also defined law as a command made by a sovereign for an inferior being, and which the inferior being has a duty to obey or suffer punishment. What you can see from these definitions is that all of them have their own different views, and they've defined law based on these views that they have. But in conclusion of that, law is which regulates how persons or bodies, should behave. To put it in our own simple language. So, therefore, law is a code of conduct for persons, bodies, and society in general. And then that takes us to another level of looking at what law is. And this makes us to look at law and under the various schools of thoughts. Law under the various school of thoughts. Okay? So now, when we're talking about definition of law, we have given general definition. We have looked at definition provided by some scholars. And now said we want to look at definition of law under the school of thought. Now, to provide an answer for the definition of law, it is what will make us to further go.
Hello? Hi, Imo. So are you there?
Hello, I think I lost connection. I attempt to answer the question, what is law? It's what is making us to consider the various school of thought that have evolved over time. And when you are considering topics like this as a university student, it goes beyond just, but we need to look at a lot of things surrounding it. So what do we mean by a school of thought? A school of thought is a belief or a system of beliefs accepted as authoritative. Simply put, school of thought represent the views of philosophers who define law from the same
Excuse me, sir.
perspective. When you look at the definitions that I gave to us,
Excuse me, sir.
Hello, please. I don't know your name, but like we've been instructed if you want to say something, yeah, you raise your hand instead of just interrupting the class.
hello class. Hello.
Hello, sir. Hello, sir. We can hear
Hello,
you.
sir. We can hear you.
I'm, I'm having some network issues here. Some of you are disturbing this are just disturbing the flow. But God has rescued me from you. Okay. So we're talking about school of thought before the network cuts the flow. And we said that the school of thought represents the views of philosophers who define law from the same perspective. So the various school of thought that we are going to be looking at exist due to the diverse background and orientation of jurists who have over time tried to define law. And some of them were lawyers, some were judges, some also are historians, and so on and so forth. All of these individuals define law based on what they consider law to be. And the reason why we don't want to look at them is to further deepen our understanding on the topic. Yamarachi, you are raising your hand. What can we do for you? Hello, Amarachi, can you hear me? Amarachi, can you speak?
Yes, sir. I wasn't hearing you before. That was when the network was having issues. That's why I raised my hand.
All right, so we are back now. All right. So, and the first school of thought we are going to look at is a natural law school. Can anybody speak to this school based on the previous lecture that you have taken when we were having these classes with other levels? Yes. Phuket, let's have you. So this is an opportunity for you to show your skill or to show how much of this course you've learned. Yes, you can speak, Rose. Why are you guys raising your hand and you cannot speak now?
Good evening, sir.
Yeah, good evening.
Okay.
You want to talk to us about the natural law school?
Yes, sir.
Yeah, go ahead, please.
Okay. You taught us that the natural law school focuses on what is fair and just. They see law as what flows from a divine or supernatural origin. And for a law to be valid, it must obey some natural principles. And the weaknesses of this law school is the weaknesses of the natural law school is that okay, the school is sorry. Their weaknesses is what is fair and just. That's their weaknesses. What is fair and just is the weaknesses of the natural law school. That's what I know about the natural law.
All right, thank you very much. Yes, who else wants to speak?
Good evening, sir.
Good evening.
Sir, I just want to add to what she said about the natural law schools. The weaknesses of the natural law school is that different people have different opinions on what is fair and just. So the what is fair and just to Mr. A is different from what is fair and just to Mr. B. And according to the way I understand it, I gave an example. I'm giving an example now that maybe somebody stole a pen, sha. So they now took the person to court. Some people might be saying that okay, that he's supposed to be punished for what he did. And others might be saying that it's because he does not have money to buy pen, or it's because he did not have a pen. That was why he stole the pen. So different people have their different opinions on what is fair and just, sha. That's what I have to say, sir.
All right, thank you. That's a good one. Yes, any other person? Amarachi, you are raising your hand. If you don't know how to use these features, why don't you just remove it so that you don't keep us hanging? All right, so yes, Adegbile.
So
Ezekiel.
I would like to say that the natural school of thought, I want to add something to it.
Yeah, go ahead.
So it can be seen as a law, a school of thought that is, put in place by God to just rule. Is a school of thought that you cannot refer to any philosopher as the founder of it. It's just there. Either it is fair or just either we like it or not, we cannot change it. It's just there, made to rule the universe.
Okay, all right, thank you for your contribution, but let me just correct you. Yes, natural law, they are put in place by God. Yes, it's not a product of legislature or parliament, but we refer to some people who has expanded it, who believe in the school as exponents of the school. And, these were the people who helped to popularize the natural law school. And they are the group of people who believe that law is what flows from divine origin, like the first speaker rightly stated. So, according to the school of thought, this school of thought believe that for a human law to be referred to as valid law, such law must conform to certain objective moral principle. Yeah, it was stated by that speaker. And we have people who are referred to as exponents in this. Please just give me 1 minute. We have people, scholars that we refer to as exponents of the school of thought. And of course, these are people who, propounded, who worked on it to make it become what it is, to formulate all of the things that we have said about it. And then they also supported it because of their background, or because of their religion, or because of the kind of work they were doing. So we have examples like St. Thomas Aquinas, we have Grotius, and so on and so forth. And then we said in our previous lectures that the natural law school serves as a validity check on the powers of the monarch. And what that means is that there are some things that are naturally okay to judge others. For example, if we really talk about what is fair to one person, like we said, may not be the same to the other party. Like in the case of our nation, for example, where we believe that every citizen of this country should be entitled to eat from the national cake. okay, if it is times of good road, in terms of good water, in terms of good social amenities, we are supposed to be able to benefit from it. But what we see is that some people who find themselves in position carry away what's supposed to belong to everybody. And what justification do they give? Sometimes they go as far as saying that they contested for the election, they fought for the election, they almost lost their lives for the election. Therefore, whatever comes their way becomes theirs alone. And that if you as an individual wants to also eat it, go and contest for that particular position to be able to have access to it. To that individual, that is fair. And to the person who feels that we voted for you in order for you to give back to us, that is not fair. But all of them, at one point or the other, may be entitled to their position. So that is for the natural law school. They believe that everything is totally subject to the will of God. Now, let's look at the second school of thought, which is the positive law school. This school of thought define law as what the sovereign says law is. That is, what the appointed leader has put forward as law, and that nothing can be law except that which the superior has put forward in form of law for the society. And they believe that this one is the opposite of natural law, because natural law is put in place by nature, by divine powers, and not by any man. But the positive school of thought talks about law from the angle of the sovereign who makes the law. Like for example, in our own state as in Nigeria, as a state, Nigeria is a country, an authority on its own, and the same country made power to be vested on the legislature, and they now have the duty to make laws for the federation. So that is a law made by human being as against what we saw under the natural law as law put in place by God or law put in place by nature to govern man and his environment. So, who are the scholars behind this school of thought? As you may have known, we have John Austin, we have Hans Kensman, and we also have Thomas Hobbes. These are examples of scholars that are, behind the positive law school. And then this school of thought believes that it is law made by the sovereign that makes the society to have some form of order and stability. Meaning that without positive law, according to this school of thought, then there will be no society. And then one thing we also need to note about this school of thought is what we consider as the weaknesses of this school of thought. And one of the major weaknesses of this school of thought is the fact that the political nature of the sovereign is not put in place. Because a president once said in this country that if a particular region did not vote for him, why should he do good for the region? So meaning if that kind of a person as president was in a position to make law, he will make law to favor those that voted for him, and those that did not vote for him may suffer for their choice of not voting for him. Another weakness with this school of thought is that the law or the school does not see international law as a good law because it does not emanate from any superior. That because naturally public international law is a product of agreements between nations who come together to have an agreement, meaning that in the midst of them, there is no leader. Everybody is a leader from the face of it. Okay? So that is one major weakness of the positive law school. Another school of thought that we will also look at is what is known as the historical law school. And I want somebody to speak to that, at least flowing from the knowledge that we have gathered from the other lectures that we have had. I can see Obum raising his or her hand. You can speak to historical law school.
Hello, sir.
Yes, please.
Sir, you talked about the historical law school and define it as the law as a product of historical development, that they believe law is an outgrowth from history and not just something that came out of nowhere. Yes, sir. So that's what I got down for historical law school, what you said about historical law school.
Okay. Can we have addition from the floor?
Hello, sir. Good evening, sir. Can you hear me?
I can hear you. Go ahead, please.
Okay, yes, sir. You also spoke about their weaknesses. You said that the weakness of this historical law school is that it's a question of how long the people must engage in a practice before it can be regarded as a law. And then you gave us exponents also from it. You gave us Gustav von Hugo, you gave us Carl von Savary, and then you say they believe that law is made for a society where there must be good understanding of the history of the people. So yeah, you said of the history of the people that before anything can be law, that you, the lawmaker, must understand. They said the lawmaker must understand the history of the people before anything can be law. Yeah. And they view law that you said that they view law. Sorry, you say they view law according to the way of life of the people. Yeah.
Yeah. And yeah, you did well. That's a good summary of the historical law school. Yes, somebody else wants to add something to it. Rose?
Okay, so I just wanted to add to what they've already said. You said the historical law school defines law as a product of historic development. They believe that the history of the people should be the foundation of their law. That way, the people will be able to obey the law. And you also gave us the weaknesses, which as
I
I
gave
said,
you
the weaknesses of this law school
You said one of their weaknesses is how long must the people engage in the practice before it can be regarded as law? And at what point can it be said that the way of the life of the people, and as such, a particular rule or law has lost acceptability?
All right, thank you. That's a very good one. I think that summarizes the content I gave on the historical law school. The main focus of the historical law school is the fact that the way of life of the people is central to the development of law. That is, law is supposed to emanate the history, that is even the culture of the people. And the only thing that was not said that wasn't said and I'm adding as an addition to this school of thought is that we have an example of this school of thought readily in Nigeria, and that is customary law. Our customary law is an example of the laws that comes under the historical law school. Now, also, we gave example of Gustav von Hugo as one of the exponents, that is, those who believe in the school of thought, who over time has done one or two things to further enlarge the course of the historical law school. And also we have Carl von Bibney as another example of exponents of this school of thought. Also, we also noted that under this school of thought, those witnesses make whatever definition that they will provide not to be the total definition, because the issue of the number of how long a particular custom must have been in place before it can become a law is an issue, because who now sit down to calculate when and when a particular law came into existence and when is going to be overtaken by event. All right, so with that, that gives us a summary of the historical law school. Now let's look at the realist law school. The realist law school pertains or concerns itself with definition relating to how courts provide solution to disputes that may arise from the particular issue that is brought before it. And the school believes that all that may have been written in law may not be as important as what the court says that law is. The school of thought believes that it is the actual interpretation of the law by the courts that is what law is. And that's why they define law as the prophecies of what the court will do and nothing more pretentious. And of course, the school of thought emphasized the element of uncertainty in law and the role of judges in lawmaking, that even though the judges do not have the traditional duty to make laws, but this school of thought believes that it is whatever interpretation that the judges give that is the utmost law. And we have example of scholars in this school of thought, to include Oliver Wendell Holmes, to include Carl Lewley, and Jeremy Frank. All of these are the major exponents of this school of thought. And then, of course, each of the school of thought that we have discussed have their own weaknesses alike. So also is the realist law school. And its own weakness is the fact that it focuses mainly on the court system. That is, it is the court who is able to determine what law is, and nothing more, nothing less. And the other school of thought that we will look at to also look at this definitional issue that we're talking about is the utilitarian school of thought. The utilitarian school of thought. And of course, like I explained earlier on, that this school of thought is of the view that proper laws are those which promote the greatest happiness for the greatest number in the society. That is, the majority happens to be in focus. And the question you will ask is that if a particular law focuses on the greatest happiness of greater number, what happens to the minority? So any law that does not cater for the majority is no law to the utilitarian school of thought. And of course, what they are saying is that consequently, if the legislature is going to make any law at all, the law must obey the rule that this school uphold very seriously. That is, that the law must be a law that will benefit the majority of the people. But when we look at it closely also, we notice that it is very difficult to make a law that everybody will agree with. That is not practically possible. But the Unitarian school of thought believes that once the majority are happy, the minorities' issues are of less concern. Okay? So, in other words, the Unitarian school of thought focuses on the majority. And examples of scholars in this field of study are Jeremy Bentham, who they believe that law is that which brings happiness to the greatest number of people in the society. And then, just like other school of thought, this school of thought also has its own deficiency, which is the fact that it focuses mainly on the majority of the people. That is, it favors the majority, and the minority are not considered as very important in the scheme of things. Whereas the society is to be for all and not just for some majority. It's supposed to cater for the entire community. So with that, we have looked at the various school of thought in line with how we choose to define law, or how law is understood by the various scholars who have existed over time and have made proposition as to what the law really is. So I don't know if there's any question, but by way of summary, the different background and experiences of these various scholars that we have mentioned is what has informed their conception of the law from the different angle that they have defined law. Those who are judges gave definition based on the court system. Those who are jurists who are historians gave definition based on their expertise. What about those that are clergy people? They also gave definition based on the way they perceive law, based on the religion that they have. But in all of this, we submit that there is no better view, that none of this school is entirely right or wrong. Against this background, then, it is better for us to describe law rather than define it. So, law is better described than defined. That is the conclusion of the whole matter. Yet, this school of thought are acceptable, but they do not have it all, because they have one or two issues that that do not represent the general belief, or most, maybe the greatest number of those in the society. So therefore, we will just look at them and see them in the way that they have defined this law, and then learn from their submissions in order for us to enrich our knowledge on the particular topic that we are dealing with. So I'd like to pause here to take any question, if there is any. Any question? All right, so if there is no question, we are therefore going to end the class here today. And then when we reconvene, we're going to start from the nature of law. The nature of law. Of course, that will bring about the characteristics of law to our mind. So I thank you very much for listening. When we reconvene again, we'll take the lecture from there. Thank you very much and enjoy the rest of your day.
Thank you, sir.
Thank you, sir.